Hi dear friend, most welcome to the channel. In series of law, our topic for today is jurimetrics. Jurimetrics, there is very less material available in India, and especially law student, postgraduate law student struggle a lot to get material. And there is one major question coming on jurimetrics in postgraduate law examination. We have compiled material to suit the requirement and current scenario in India regarding the jurimetrics. Let us go through it quickly. First, we will understand the meaning of jurimetrics. So basically, it is consist of two words: juris plus matrix. Juris means law, and matrix means science. So in simple way, jurimetrics is study of law and science together, and it involves strictly empirical approach to the law. So what is empirical approach? Where mathematical formulae are not available, the mathematician or scientist do trial and error, and based upon the result they generate some formula and apply till actual formulas are available. In the same way, jurimetrics concept is made similarly to that empirical approach. We will understand it in little detail. Simplest meaning, jurimetrics, science of law. Let us see some background of the origin of this term jurimetrics. The first time Mr. Loinger used the term jurimetrics first time in 1949. However, the term whatever he used jurimetrics was little different than it is in context of today. He used jurimetrics term to have all these jurisprudence related judicial decision, to have tabulation of all the judicial decision passed and making some output, making some trend based upon the different judicial decision. In summary, we can understand that how the past judicial decisions can be used as a mathematical data for a future reference. That efforts was made by Mr. Luinger in 1949. However, later in 1960, in USA, Jurimetrics magazine was started, and it was a totally shift from what Luinger did in 1949. And this magazine on the name of Jurimetrics mainly focus on application of computer in the law practice. How application of law in the computer law practice? In the area of legal research, evidence analysis and data management. And what is this? We will discuss in little detail in coming slides. So please be with us. To understand jury matrix, we will have little overview of judicial system. Although many law students already know this judicial system, but as a quick reference, it is useful here to understand comparison for quick understanding of jury matrix. You see, in judicial system, there are two clients; those are having some dispute, and to resolve the dispute and get judgment, they approach to the advocates. And what advocates do they go to the court where judge is there, and based upon the fact and the law, and also the judicial decision of the past on the similar case, these are called precedent. All three together they apply and make the case and present to the judicial authority or court or judge. And then based upon the fact and all these things, the judge deliver the judge. So this is the overall judicial system in simply. Looks so simple, but being human intervention in between, lot of variation and lot of subjectivity. And the reason for subjectivity, as you know, is mainly many time it is ability of judge, mental status or mood of the judge, and the pre-notions and biases of the judge based upon the his growth and development, his childhood experiences, etc. So all this depends, which may affect the outcome of the particular case. In same case, judicial decision may be different. So these are the issues, and it also affects because of advocate ability, his or her experience, and how much efforts or hard work the advocate has put to prepare the court. So all these are the scope of subjectivity, where outcome of the same case may vary. As you know, in India before 2020, adultery was offense, and there were several cases related to adultery where the person, the male person involved in adultery, got prosecuted. But in 2020, now adultery is not an offense in India. India remains same country, and adultery also remain the same thing. But it is no more offense. Why? Why? Because all these variable things, the judge thinking, the mindset of the judge, and the ability of advocate. So these are the variation factor where the case remains same but output may vary. So this is overview of judicial system. The challenge, biggest challenge in front of judiciary is how to control to this unvariable behavior to get a desired outcome which is close to the right one. And this is how computerized judicial system everybody is anticipating can help in this. So let us see that if there is no judge, there is no advocate, there is only client, and if we have a computer, how, let us imagine how we will get the judicial decision or judgment only by application of computer. What will happen? Someone will feed to the computer all the fact related to the case, all the law related to the case, and the past judicial decision, those are precedent with respect to that particular dispute or case. Now it is computer who will analyze, who will process, who will interpret all this information, and based upon the input given, it will give judicial judgment, it will give decision. It looks so fancy now. There is no need of court, no need of judge, no need of advocate. Only computer will deliver all the judgment. And this imaginary concept is basically jury matrix. Though it is a imaginary one, and no ideal state is very difficult to achieve. But in broad sense, you can understand jury matrix is a concept where no all computerized system is used for judicial processing, where all the input are given to the computer either through advocate or through client or through judiciary or through parliament, whatsoever it is, and the software of the computer designed for this specific purpose. One of them is Lex actually, and there are many others also nowadays available. And based upon all this information, they give this decision. And this concept is called jury matrix. Now the question is whether it is somewhere it is in use or no. No, for directly delivering of justice, it is nowhere used. The limitation are software design. How much effective software design we have done for this, and how much accuracy of fact we are providing to the computer, and how we have applied the law and use of artificial intelligence in the computer itself, learning by its own past interpretation of judgment and data. All these are variable things which here computer also got no bias and may give wrong result because of all this subjectivity or variations. Now, why law cannot be purely scientific? So this is a very debatable question. No, science has definite input and that definite output, but law it is not always. Why? Why so? Let us understand it. Because we'll see only one example: science of gravity. So science of gravity we know from the Newton concept. If there is a fruit on the tree and it fall because fruit has mass like apple, due to gravity effect it will definitely come down to the ground or earth only. So this is the science of gravity and universal rule perfectly applicable everywhere where there is gravity. Now let us see law for murder. Law for murder, as we know, as a general ordinary person, somebody do murder and the punishment is hanging, death by hanging or phansi, whatever we say. But the cause of murder may vary, and the person who has done murder also may vary. So lot of variation in this field. For example, if a insane person do a murder, whether he or she should be hanged or not. So this is a debatable question. Another is if a child less than 6 year old in most of the law of the world is not punishable under any offense. And you see, this sort of variations create problem where no science of gravity can be applied uniformly, but law for any offense cannot be applied straightforwardly because of all these human behavior variations. And there is another doctrine in this respect, doctrine of logical plenitude. They say that in this universe there is possibility of everything. Possibility of everything mean if a person fall because of slip, trip and fall, he may die also and he may not have even any injury and he may have fracture also. So all these are variation, but the cause was only fall. And this is applied to law actually, where our input may be same but variation may be the great diversified. And this is how concept of jurimetrics is being introduced to have control on the aspect of variations to get a guided result. Now, how legal system can have scientific approach? Though it is a very very difficult question, but it can help us if we have right law available, fact available, and judicial trend means the past judgment given by the court on the same type of dispute, and these can be fit into the empirical formulas or it can be fed to the computer like software lex we discussed before legal expert system, and all these informations computer can process and give the probable result that can be used to calibrate or take reference in actual judgments. So this is how use of jury matrix can be helpful for overall administration of justice or judicial system. Now, many times students get confused between jurisprudence and jury matrix. And in exam also, they write whatever they know about jurisprudence to the jury matrix also, and because of this, they did not get rejected. So we have a couple of slides here to understand difference quickly. The jurisprudence as management law is basically study of law, its nature, its sources of law, and its basis of law, and how law got evolved from the different location, different geography, different morality, and how law got eliminate or die or deleted itself when it is not relevant. This all is basically jurisprudence. Jurimetrics start when jurisprudence end. So wherever jurisprudence give output, it's used as a quantitative analysis. Jurimetrics use quantitative analysis of all the judicial behavior those are coming from jurisprudence, and it is applied systematically or mathematically, and when computer is applied in electrical form to get probable legal predictability. So in summary, whatever concept jurisprudence give, jury metrics use it, interpret it all the data, and give the legal possible predictions to guide the judicial system or the court whether they are doing right decision or not. So jurimetrics is efforts in the science to apply the science in the field of law. In simply, if we say jurimetrics is an effort that how law can be more scientific. Where jurisprudence can be debatable, we can have all philosophy debate all the time, but jurimetrics results can be testable. Testable in the sense, in particular condition, what are the result when judge are changed, how the behavior of judge when feeded to the jurimetrics will change the result also that can also be tested. And as we discussed before, jurisprudence focus on law and its values. However, jury metrics focus on method of inquiry and investigation of the jury metric of the cases. It may be simply said that jury metrics is the applications of science and computer together, whatever outcome we receive from the jurisprudence to have a effective administration of justice. There are limitation also here in jury metrics also, because computer limitation is whatever input you will give, this output will be also accordingly. So in case of group or individual approach, if you will feed the input to the computer of a particular judge, it will give result based upon that particular judge, and it will have information based upon the judicial decision given by multiple judges. The output will also vary based upon the information fed to it, and in simple term we can understand the term gigo applied to the computer. Full form is garbage in, garbage out. So whatever information we will feed in, the result will be accordingly. The more accurate information, more accurate result. More vague information, the vague result. Let us summarize whatever we have understood quickly. Jury matrix is application of modern logic, scientific, mathematicals, and computer techniques or computer software to the legal field. Please note that in nowadays, very less computer application is in the judicial system or administration of justice. But jury matrix is an effort where all this information, if you will feed to the system, he will keep the system will give accurate predictions of the judicial decision that can be used by judges or judiciary. However, jury matrix does not give any social answer. Means its direct decision cannot be used. However, this can be took as a reference to guide the judges or judiciary. And it is not substitute of jurisprudence. It is only a scientific applications and helping and support to the administration of justice. Thus, in the last we can say that it has two dimensions. One is technology and computer advancement and helping the interpretation of data by the software available with the computer and giving prediction of the decisions. In particular case, whatever input we will feed, whatever related to the judge behavior information, precedent, law, and the fact of the case we will feed, the prediction of decisions can be used to control the mental behavior or the social background of the judge or whosoever is going to handle the case and going to give the decision. So we can understand that how particular applications of computer in the form of jury matrix can help judiciary to have a best possible judgment, taking reference of the jury matrix as well as and having a parallel uh, trial of the case using fact, law, and judicial decision of the past. I hope we will get idea of the jury matrix and difference with the jurisprudence of it. If you have little doubt, please go through this video again. You will get more clarity. And if you have any query, please write in the comments. And you can also mention your query to the WhatsApp number given here. Thanks for watching this. Please share your feedback and share this video to your friends for their benefit. Thank you so much.